Right, well, good morning, everyone. My name is Andrew Brown, barrister at Radcliffe Chambers. I'm joined by my frighteningly intelligent colleague, Matthew Mills, and we'll be speaking about insolvency law at this junior program this morning. I'm joining you from my son's bedroom, so if you see a crib in the background or children's toys, I apologize now. I'll probably be playing with those while Matt's talking. I think Matt is also joining us from his home, but he's quite wisely taken any offensive things off the wall behind him. So today we're going to start with Matt's talk on limitation and insolvency applications, and then we'll turn to my less exciting talk on void dispositions.
Good morning, everyone. As Andrew said, my name is Matt Mills, and I'm here to talk to you about limitation and insolvency. I've taken my inspiration for this webinar from a recent Court of Appeal case, which I'll come to in a bit. But overall, I'll essentially be discussing two things. First, limitation periods in insolvency. And second, how limitation affects the service of insolvency applications. Now, these issues are actually really important because if you get them wrong, your claim can be over before it's really even begun, and you could end up with an adverse cost order against you and legal hair dye dripping down your legal face. Let's dive straight into limitation periods then. I'll divide this topic into 4 steps. Claims by the insolvent party, claims by creditors, claims by office holders, and then some practical tips to help bring it back down to earth. But before I move on to that, it's time for a fun fact. The limitation of debts was first introduced by statute in 1623, the same year that Shakespeare's first folio was published. However, it wasn't until 1997, when Harry Potter was first published, that the English courts first recognised limitation in office holders' applications. And who says the law isn't a fast-paced profession, eh? And with that background in mind, let's turn to the substance. Claims by the insolvent party. Now, as you all know, liquidators have the power to bring or defend any action or other legal proceedings in the name of and on behalf of the company. And trustees in bankruptcy have a similar power as well. Fortunately, for limitation purposes, the general rule is very straightforward. The onset of limitation does not affect the underlying period. For example, for a breach of contract claim, the limitation period is likely still to be 6 years from the date of breach of contract. However, there's an exception. If a company is dissolved and then reinstated to be put into liquidation, the court has the power to order that time is deemed not to have run for the period of dissolution. This is called a limitation direction. Now, there are relatively few reported cases on this issue, but most of them emphasize that the court will only do this in exceptional circumstances. For example, in the Pickering case, the court emphasized the applicant must show there's a causal link between the dissolution of the company and the failure to issue a claim against it. Let's now look at the other side of the coin then, creditors. And there are essentially 3 different stages for us to consider here: statutory demands and petitions, proving an insolvency, and then suing the insolvent party. Now, at the demands and petition stage, there are 4 key principles. The first is that a statutory demand will be set aside if the debt is statute barred at the time of service. Similarly, a petition will be dismissed if the debt statute barred at the time of presentation. However, it's not a problem if the limitation period expires after presentation, even if it expires before the first hearing of the petition. Furthermore, the Court of Appeal has told us that a creditor can petition based on a judgment which is more than 6 years old. Now, the default rule in Section 24 of the Limitation Act is that no action shall be brought to enforce any judgment after 6 years. However, according to the Court of Appeal in the Ridgeway Motor case, a petition is not an action on a judgment. It's, and I quote, a sui generis collective enforcement procedure for the benefit of all creditors. In other words, it's different. So that's enough Latin for a Thursday morning. Let's move on to proving debts. Rules 14.1 and 14.2 of the insolvency rules confirm that a creditor can prove for a debt in insolvency if it's outstanding on the relevant date. In practice, that means the date of administration, bankruptcy, or liquidation. Any debts which are statute barred before then are not provable. Now, it's likely that this general principle also applies in most IVAs, because the courts have said they're willing to imply a term into an IVA, if there isn't an express one, that the debtor forgoes the benefit of any limitation period. However, do make sure you look into this if it might be relevant for your client, because it's obviously undesirable to have to rely on an implied term rather than an express one. So that's the basic rule. The key time is the date on which the relevant party goes into insolvency. However, like all good legal doctrines, there are caveats to this, and unfortunately, there's 6 of them. Firstly, time stops running for the petitioning creditor at the earlier date of presentation of the petition. Now, in some cases, that can give the petition creditor quite a significant gap of additional time between presentation and the hearing. Secondly, it does not matter if the debt is barred by limitation after the order is made, even if you haven't yet proved. As I said, the relevant time in most cases is the date of the order. However, time does not stop running for debts which are outside the scope of bankruptcy. For example, claims to enforce a security or a personal injury claim, which is not discharged by the bankruptcy. Fourthly, if a bankruptcy order is annulled, then there's old authority, read Dennis, which suggests that the limitation period will essentially be deemed to have continued throughout. So you could lose the benefit of this stopping in time, which can obviously be a big problem for your client. Fifthly, here's a big one. Administration does not automatically suspend any limitation periods because it does not impose a statutory scheme of rateable division on the company's assets. So if your client has an old debt against a company that's about to go into administration, it may be advisable to seek either a written acknowledgement from the administrator that the company does owe the debt, or at least get consent from the administrator to bring a claim against the company so you don't lose the claim for limitation purposes. Finally, this one's a bit niche. It's possible that insolvency will not stop time running for any contractually agreed limitation periods. By that I mean clauses in contracts which say party A must bring a claim against party B within 12 months of the relevant event. So that's creditors and proving. The final way that insolvency might be relevant to creditors is when they want to sue the insolvent party. Except in administration, limitations generally suspended during insolvency, as I've just explained. Furthermore, having a judgment against the insolvent party generally offers no advantage over an admitted debt, and it's unlikely to be cost-effective to sue an insolvent company or person in any event. However, your client may need to do this if the debt is jointly owed by the insolvent party and someone else, for example, as a joint debtor or as a guarantor, because in those circumstances, you may need to pursue the insolvent party to be able to pursue the non-insolvent party later. So do bear this in mind when deciding what stance to take when the company or person goes into insolvency. So that was creditors. Let's move on now to office holders. Now, the first important point is try not to confuse time periods. For example, for antecedent transaction claims, the Insolvency Act refers to various different periods, say 6 months and 2 years. These are not, strictly speaking, limitation periods. These are simply the periods during which transactions may be challenged. A limitation period, in contrast, is how long you have to bring that challenge later on. Now, the Insolvency Act is silent on limitation periods, so we need to turn to our old friend, the Limitation Act of 1980, and in particular, sections 8 and 9. Section 8.1 states that an action upon a specialty has a 12-year limitation period. However, section 8.2 confirms that if the Act provides a shorter period elsewhere, it's the shorter period that applies, not the 12-year one. And this is where section 9.1 is relevant. 9.1 confirms that an action to recover any sum recoverable by virtue of any enactment has a 6-year limitation period. Now, in this context, specialty includes any obligation imposed by statute, including those, most of them, relevant to claims by office holders. So what is the relevant period? Is it 6 years or is it 12 years? Unfortunately, for those advising clients, the answer is it depends. Now, that's not a particularly helpful answer to give, so what I'll do over the next few slides is break down the different types of office holder claims and go through the relevant principles for you. Let's start with antecedent transactions. The key case here is re priori garage, and there are 4 key principles to bear in mind. Firstly, a claim to set aside a transaction or release or discharge a security is a specialty and therefore has a 12-year limitation period. In contrast, a claim simply to recover a sum of money or set aside a payment of money is not, and is a 6-year limitation period. However, if your claim for money is genuinely ancillary to your specialty claim, then both of them are governed by the 12-year period. For example, in the priori garage case, the judge said, if the office holder is claiming the reversal of a transfer of property and then lost rent for the relevant period, both would be governed by the 12-year period. The judge also said that where there's doubt over what's substantively being claimed, the court would look at the substance or essential nature of the relief truly sought. Now, importantly, the court will not simply look at the words you use in your application form or witness statement, they'll look at the substance underlying it. So some clever synonym searching won't help you out here. It has to genuinely be a claim for something other than money. Let's move on then to wrongful and fraudulent trading claims. These types of claims tend to be about recovering money, so the 6-year limitation period is likely to apply in most cases. And time starts to run once the company goes into liquidation or administration. Skipping on then to transactions defrauding creditors. The Court of Appeal has essentially endorsed the same approach as priori garage. So either it's a 6-year period or a 12-year period, depending on what the substance of the claim really is. Importantly though here, it's possible to have multiple limitation periods in respect of the same transaction. The Court of Appeal has said that time starts to run for victims when the transaction occurs, but time only starts to run for the office holder when the bankruptcy or winding up order is made. So you could have 2 different limitation periods expiring at 2 different times for the same action. And that can be a bit confusing, so it's something to bear in mind. Finally, let's look at misfeasance claims. The key case is re Eurocruit. And in that case, Mr. Justice Blackburn held that Section 212 is essentially a procedural provision, which allows a liquidator to bring proceedings in their own name, which could have been brought by the company itself. For example, a claim in negligence or breach of contract, or a claim in restitution. As a result, the limitation period is simply whatever applies to the underlying substantive claim. For example, a claim for breach of contract is likely to have a 6-year limitation period from the date of breach. Importantly, limitation does not restart on insolvency. Limitation starts, as usual, whenever there's a breach of contract or loss is suffered for tort and so on. So it's very important for liquidators to investigate these types of claims promptly, because it's quite possible that the relevant events occurred many years ago and limitation is about to expire imminently. Now I've just thrown an awful lot of law and cases at you, but don't worry, you'll get the slides after this, so you don't have to be scribbling it down. But to help you practically deal with this, I've come up with my 5 top tips for dealing with limitation periods in insolvency applications. Number 1 is advise any office holders to act promptly. This is for 3 reasons. Firstly, as I explained earlier, in many cases, they might only have 6 years rather than the 12 years they want. Secondly, in particular for misfeasance claims, the 6 years might have started several years ago, so they really might not have very long at all to put something together an issue. And thirdly, and this is a new point, in Hamben and Field, the court confirmed that even if an office holder has acted within a limitation period, it's still possible to strike out a claim if it's proceeded with in inordinate delay or inexcusable delay. My second tip is if a limitation period is about to expire, write to the other side and ask them to enter into a standstill agreement or give a written acknowledgement of the debt. Now, the reason I've cited re compania is because it's sometimes possible to argue that if the company has signed its accounts and those accounts record your debt and those accounts have been sent to you, this amounts to a written acknowledgement. So don't forget to look into that possibility if you're considering this issue. Now, you might be wondering, why on earth would the other side agree to any of these things? Because they only really benefit you. Well, you can emphasize 2 things to the potentially or insolvent debtor. Firstly, issuing a legal claim has negative reputational consequences for many defendants and respondents. Obviously, avoiding that is a benefit to them. But secondly, extending a limitation period would allow you potentially to engage in settlement negotiations, which again avoids the expense, stress, and time of going to court. My third tip is that if you're running short of time for a misfeasance claim, you could consider issuing it as a Part 7 claim rather than an insolvency application. That will then give you the extra 4 months between issue to serve and draft your particulars. Whereas with an insolvency application, everything needs to go in up front. A fourth tip is don't forget the 4 important statutory exceptions in the Limitation Act itself. The first 2 are in section 21(1). No limitation period applies to claims in respect of fraudulent breaches of trust or claims to recover trust property. Both of these situations have been held to apply to directors. The other 2 exceptions come from section 32(1), and that confirms that the start of the limitation period is postponed if the claim is based on the defendant's fraud or if the defendant has deliberately concealed a relevant fact. Fortunately here, section 32(2) tells us the court will essentially infer deliberate concealment if the breach was deliberate and it's unlikely that it would have been discovered for some time. So if you have shady directors' dealings in the run-up to insolvency, this provision can be very helpful to buy you a bit of extra time. My final tip is that if an office holder's potential claim is subject to a 6-year limitation period, and more than 6 years has elapsed, then you should really only consider claiming something other than the repayment of money to get yourself within the 12-year limitation period. Now, obviously, do remember the court will look at the substance of the claim here, so you can't just pull the wool over their eyes. But if you can find something that's a non-payment of money case, this can really help you. Now, having heard all of this law about limitation, I know what you're thinking. What could possibly be more exciting than limitation periods? And I know what you're thinking, limitation and service. And that's what I'll talk about for the final part of this webinar. The reason I'm talking to you about this is because deputy judges have been reaching different conclusions on this issue over the last few years. But in November, the Court of Appeal finally gave us a definitive answer. And the debate all stems from Rule 12.9 of the Insolvency Rules. In a nutshell, this states that an applicant in insolvency proceedings must serve their application at least 14 days before the date fixed for its hearing, unless the court or statute permits otherwise. Now, I'm sure everyone listening has had an insolvency application adjourned for the first hearing, for example, on the papers because it's judicial unavailability due to a consent order, or because there was an issue of service that could be dealt with on the papers. If the court does adjourn that first hearing and it doesn't go ahead, what is the hearing for the purposes of Rule 12.9? Is it the date written on the application form, or is it the date of the first hearing where everybody actually turns up and has an argument about something? This is where re-eyed comes into it. The Court of Appeal unanimously held that it's the first hearing that matters, even if that hearing is ineffective, adjourned, or vacated. In fact, the Court of Appeal even suggested, albeit obiter, that if the first hearing was brought forwards from the original date, it's the brought forwards date that matters. For example, imagine you issue an application in the ICC court today. The court lists it for the 18th of March, but due to unexpected availability, they offer to bring it forwards by a week to the 11th of March. Even though you've got the 18th of March written on your application form, re-eyed suggests you should work backwards from the 11th, the earlier date. Now, I accept that that's unlikely to happen very often in practice, but it is another reason why applicants should not aim to serve their application right at the last second, because an unexpected change like that could really catch them out. The second point to bear in mind here is, in my view, this conclusion is equally likely to apply under Rule 12.28, which deals with the service of expert reports or reports and witness statements. That section uses the same phrase as 12.9. Okay, so I've said a lot there, but what we've basically come down to is the hearing means the first hearing. That's not exactly rocket science, Matt. And how does limitation come into this? Well, this is where the second part of re-eyed matters. As we saw earlier, under Rule 12.9, the court can extend the period for service of an application. What the court concluded in Re-Eyed was, when deciding whether to make such an order, the court should take into account any potential limitation defences. Now, although this is arguably new in insolvency law, this is obviously a long-standing principle in the CPR more generally. See Rule 7.6 of the CPR. So what will the court look at when deciding whether to make an extension of time in a limitation period type case? Well, fortunately for you, I've done the legwork, and over the next few slides, I'll summarise the key principles from the insolvency cases and a couple of the key CPR cases as well. The starting point is that when a limitation period has expired, the court will only exceptionally extend time for service. Secondly, last year, Judge Prentice confirmed that late service cannot be cured by the insolvency lawyer's favourite rule, 12.64, so you can't cheat this one, I'm afraid. Thirdly, giving more practical examples, if you're having issues serving one defendant, for example, in Re-Eyed, one of the defendants was working in a bar in Montserrat, you still need to serve the other defendants where you can. It's not enough that you simply want to serve them all at the same time. You'd likely need to persuade the court that there'd be some underhand conduct or something untoward if you serve them sequentially. Fourthly, the fact that a liquidator is still looking for ATE insurance is not a good enough reason to refrain from serving an application. The court has said that that type of insurance is primarily put in place for the office holder's benefit, and therefore shouldn't delay or prejudice the respondent's case. So even if you face financial difficulties funding the whole claim, what the court will likely expect you to do is issue and serve it, and then apply for an adjournment or a stay of later procedural steps. Fifthly, the court's unlikely to extend time for service simply because you're waiting on advice from counsel. So that's a warning to Andrew and I to step on it when we're dealing with insolvency cases near limitation. Sixthly, the court's unlikely to extend time solely because you're waiting on wider developments in the case. Now, in the structure tone case, the parties were waiting on an arbitration award in relation to a small part of the dispute. The High Court said this was not a good enough reason to refrain from serving the claim. Seventhly, fortunately, it's not all bad news. The court's likely to be receptive to an application if the applicant is in some way being thwarted in progressing their case by the respondents. In other words, if the respondents are trying to make it difficult to serve them. Furthermore, if expert evidence will be necessary to resolve the case, then the court might be more willing to grant you an extension of time. Now, in the Imperial Cancer case, it was quite technical claim about water ingress in a laboratory, but in principle, the same reasoning should apply to, say, expert accountancy evidence in an insolvency claim. 9. In Re-Eyed, Lord Justice Arnold suggested the court should be slightly more lenient with applicants in insolvency cases if they've had less than 4 months to serve. His thinking was that all things being equal, it would be harsh to penalise an insolvency applicant if they've only had, say, a month to serve, when a standard civil litigant automatically gets 4 months. Now, in my experience, many applications in the Rolls building have a first hearing listed well within 4 months. So hopefully this would give you something to say in most cases when you're seeking an application for extension of time. However, please note this isn't a free pass. Lord Justice Arnold emphasised that the court would still want to see what you've been doing in the time available to you, even if it is only, say, a month. 10thly, in Eyed, Lord Justice Newgee confirmed that if you served your application late, but there's no question of limitation, then no doubt the court will usually only adjourn your application rather than impose any harsher procedural sanction. So that can be quite helpful if you're on the other side of the limitation fence. Turning then finally to practicalities, if you need to make a last-minute application to extend time, make sure you explicitly state that there's a limitation issue and explicitly ask the court to deal with this urgently. If you don't, it might slip through the cracks and be dealt with too late. And if you don't draw limitation to the judge's attention, then when the other side receives the order, they may be able to set aside it or appeal it on the basis you didn't bring the relevant limitation period to the judge's attention. Finally, on the flip side, if you're acting for a respondent and want to set aside a without notice order extending time, make sure you act promptly. In the Re-HS case, ICC Judge Prentice refused to allow an application that was only brought 4 months before a trial was due to be listed. He said that was far too late to challenge even a without notice order extending time. So after what might have felt like a 4-month delay since Andrew spoke, thank you very much for listening. That brings me the end of my talk.
Well, thank you very much, Matt. I think it's going to be very difficult to follow that talk. That was excellent. I'm far from the headline act. I did note, interestingly, you made reference to Judge Prentice multiple times in your talk. I shall as well. So Judge Prentice is getting a lot of publicity today, no doubt for great decisions along the way. Also, something I'm going to bring up at the end of our talk, there was interesting discussion you had there, Matt, about limitation running throughout the insolvency and how that might frustrate creditors if there's an annulment along the way. There's something that I dealt with recently in an annulment. I just thought I'd raise this. That's actually grounds to prevent an annulment potentially if creditors have been prejudiced by Limitation Act running throughout the bankruptcy or the winding up, or just the bankruptcy, because you can't annul winding up. Anyway, enough waffle from me. We'll continue on with my talk now. We're talking about void dispositions under sections 127 and 284 of the Insolvency Act 1986. What is the plan of action? Now, Matt had a very fancy fade in and fade out wording on his PowerPoint. I'm too old to know how to do that. So you're just going to get everything at once. So the plan of action today, we have limited time, so in the words of one of my colleagues, Chris Buckley, this is going to be a quick and dirty overview of the subject. We're going to talk about what is a void disposition. What are the grounds for recovery that an office holder might have under a void disposition, and any limitation issues that might arise, tying in with Matt's discussion. Then we're going to talk specifically about section 127, which is the corporate insolvency rules. We're going to talk about, again, what is a disposition, what are the relevant times, and any defenses, especially the defense of change of position, which is one which is near and dear to my heart. Next, we'll talk about section 284, which is the personal bankruptcy void dispositions. Again, we'll talk about conditions there. We'll talk about potential defenses, and especially because of specific requests from many of you who are currently watching, we're going to talk about subsection 4 as a defense and the recent case of ICC Judge Prentice in Riwasu, quite a big decision which has caused some waves in the area. So we'll talk about that. Finally, we'll talk about trust property and subsection 5. Validation orders obviously have an important role to play in void dispositions. They are a subject entirely on their own because they are so significant in their own right, and I don't have time to go over them today. So we'll just briefly discuss them at the end of the talk. But you'll have to wait for one of my colleagues to give a much more nuanced talk on validation orders in the future. Hint, hint for anyone in my chambers who is listening. So introduction, what is a void disposition? Well, it concerns dispositions of property by the insolvent, either company or person, after the commencement of the winding up or in the relevant period of a bankruptcy. And we'll talk more in depth about those as we go on and deal with the section specifically. But at its heart, what these sections do is they simply void any disposition of property which happens in the relevant times. It's not voidable by choice. It's not something which can be set aside like an antecedent transaction claim. All it does is, as a matter of law, that disposition ceases to exist. That's it. Simple. You don't have to do anything more. And the purpose makes sense. It's ultimately to preserve the assets of the company or of the bankrupt, to go by the pari passu principle, to ensure that all creditors are treated equally in the winding up from the property of the company or the person at the time of the winding up. But if all it does, if all these sections do, are void the dispositions themselves, what actually is the cause of action? Well, neither section 127 nor 284 are actually causes of action in their own right. Neither one provides for a statutory scheme of clawback. All they do, as I said, is void the disposition, and they stop there. So to actually recover property, you've got to go back to the common law, step into issues of restitution and unjust enrichment. So some might note that the case of MKG Convenience Limited and liquidation, that noted that this is actually restitutionary ground. We go to the common law principles. Where the issue is one of money, then it's money had and received. And ultimately what you look for is where there is some measurable benefit which is accrued to the recipient. Well, what about limitation periods? If we're talking about common law causes of action of restitution, where does the Limitation Act fit into this? Well, it's an equitable remedy restitution. So as we all know, no doubt, from Section 36 of the Limitation Act, there is no limitation period to restitutionary claims or equitable remedies. So hooray, maybe that means no limitation will ever exist for restitutionary claim. Well, that's not quite right, because what actually happens is courts will apply or infer by analogy a limitation to restitutionary claims based on whatever they're close to. So for instance, in the payment of money, that will attract a 6-year limitation period as if it was payment of money under a contract. So we have the case of High Commissioner for Pakistan in the United Kingdom and Prince Jah. This is a famous case. I'm sure many of you might have known about it. It's money which was paid into a bank account by the Nizam of Hyderabad in 1948 with the partition of India. Sat in that bank account for a number of years. Q fight between Pakistan and India and the descendants of the Nizam as to who actually was beneficially entitled to those funds. Well, in that, at least in that hearing, which I've cited, it was determined that restitutionary claims would have, when it's an issue of simply money in return of money it hadn't received, would have a 6-year limitation period. Ultimately, I believe that money ended up going to India and the descendants of the Nizam, so Prince Jah. That's just by the by, not really important for today. However, likewise, if the issue is one of property, real property, or say shares in a company or something which is non-monetary, you'll have a longer limitation period. This is something I'm advising on in the moment. We're seeking return of company shares held by a bankrupt, which he transferred during the relevant period. That you'll see a 12-year period likely to be applied. Now, there's no case law that I've ever been able to discover specifically saying that. By analogy with what we saw in the High Commissioner for Pakistan in the United Kingdom and other cases like Akers and Samba in the Supreme Court, we expected 12-year limitation period to apply. So you still got to get on your horse and you still got to check the dates to make sure that what you're looking to get back is something which falls within the limitation period. It will be rare, I would say, that you're looking for void dispositions 12 years after the onset of insolvency, but it does happen. We all know situations like that, rare as they may be. So let's turn to section 127 itself. I've put it all out there. I'm not going to read it all out. I'm just going to highlight a few passages. So subsection 1 is really the meat and potatoes of this section, which states that in a winding up by the court, so we're talking corporate insolvency, any disposition, big word we'll have to define there, of the company's property, again, property, something we're going to have to define, and any transfers of shares or alteration in the status of the company's members made after the commencement of winding up we have to define, is, unless the court otherwise orders, void. And the otherwise orders is the validation order element of things, which we won't touch on too much. I saw one of you asked a question about administration in the Q&A box. You might want to look at subsection 2 here, which notes that this subsection has no effect in respect of anything done by an administrator of a company while a winding up petition is suspended. So if an administration exists which had the effect of suspending a winding up petition prior to liquidation of the company, the administrator can still distribute assets in the course of that administration without fear of section 127. Hooray for administrators. Subsection 3, I'm going to ignore for the purposes of today because I don't want to talk about the Financial Services and Markets Act. FSMA is not my favorite thing to talk about on a Thursday morning. So what is a disposition? Well, the disposition must ultimately relate to property, which is defined in section 436 of the Act. That could be anything which is in there. It's a huge, broad swathe of items. Money, goods, things in action. So it shows in action a right to claim against someone for breach of contract, say, would be a thing in action. Land and every description of property wherever situated, and also obligations and every description of interest, so guarantees under an obligation, whether present or future or vested or contingent, arising out of or incidental to property. Very broad definition of what property is. So we're trying to catch almost everything. the Supreme Court in Akers and Samba, which was a case involving the transfer of shares during the relevant period in corporate insolvency. A company transferred shares, which it was the trustee, it held as trustee for others. In that case, per Lord Neuberger, who of course was the president of the Supreme Court at the time, approved a definition of a disposition as a disposition should therefore be considered to include not only any dealing in the company's assets by sale, exchange, lease, charge, gift, or loan, but also any other act which in reducing or extinguishing the company's rights in an asset transfers value to another person. So you're also looking to see whether the company has, or even the individual, if you're dealing with Section 284, reduced or extinguished their right to something, and that benefit has accrued correspondingly to another party. Again, we go back to issues of restitution and unjust enrichment. Party A has lost something, Party B has gained something unjustly, something which they are ordered to ultimately make restitution for. Akers and Samba, ultimately, I have to quickly make an interjection here. 127 was found not to apply in that case, as the company held the shares as trustee. So they had no beneficial interest in the item which they transferred. They had legal title, but nothing more. So ultimately, where the beneficial interest wasn't held by the company, it didn't lose anything beneficially. Its ultimate balance sheet was not affected. So in that case, it was not reversed. Well, what about some examples? Obviously, the payment of money would be a disposition or the transfer of property. But as we said, obligations and shows as an action can also form part of property and can be caught by disposition rules. So in the case of Office Serve Technologies and Anthony Mike in 2017, what happened in that case is a company agreed with one of its directors. The director had taken a lot of money out of the company, potentially unlawfully, and the company had potential causes of action against him for a bunch of money. The company agreed to waive their rights to pursue those causes of action in return for that director returning his shares in the company. And that happened in the relevant period. And in those situations where the company gave up its right to pursue a cause of action, that was considered to be property. It was considered to be a disposition. And in that case, the settlement agreement was voided by the court, so the liquidator could pursue the director for the unlawfully taken sums. Well, under Section 127, who actually is liable? As we said, this is a restitutionary cause of action. So the person who's liable is the person who has received or accrued the benefit or the value of whatever property was disposed. That is the person to which the company will pursue, that person who has received the benefit. It's not like a misfeasance claim where you can go after the director for doing something wrong. You only can go after the person who has the funds. Standard restitution, unjust enrichment. However, it could be coupled with a misfeasance claim if a director has done something which would breach his normal duties in the course of actually making this transfer. I've got the case of Oxford Pharmaceuticals up there very briefly. Well, actually not briefly because I don't feel like talking about it. In that case, essentially, it was approved that you could do a misfeasance claim coupled against the director. Also, if one were to make a void disposition in the course of the winding up of the company, that could be grounds for disqualification of the director. And again, I've cited a case there, 2 cases if you want to take a look at them. But again, I won't go too much into depth for them today because they're not really relevant to our purpose. But what is the relevant time for Section 127? Well, it's defined as the commencement of winding up. Commencement of winding up, you might initially think, is simply the actual winding up order of the company, but that's not correct. Section 129, subsection 2 notes that the winding up of a company by the court is deemed to commence at the time of the presentation of the petition for the winding up. So we get that period between the presentation of the petition and the actual winding up order, which anyone who spent a long morning in the winding up court would know can be an extensively long period. That period might see multiple adjournments of winding up petitions and can run to months and even over a year. So it might be a huge amount of period we're looking at. which is where validation orders are very important. Again, not what we're going to talk about today. But this can catch out a lot of people, because there's no requirement in 127 that the recipients have knowledge of the winding up in order to be liable under 127. If they simply receive the property, that's that. It is a void disposition. What are the consequences of the relevant time? There are some unexpected consequences of this provision and how it relates to other elements in the Insolvency Act. And this is going to inform our discussion of rewasu a little later under Section 284. If you look at preferences under Sections 238 and TUVs under 239, the relevant time for both of those claims, reversal of those transactions, is contained in Section 240, subsection 3E, which notes the relevant time starts and ends, well, it starts at whatever period you're looking at, either 6 months or 2 years, but it ends with the commencement of winding up. And the commencement of winding up is defined, as we've already noted, in Section 129 as the presentation of the petition. So the effect of that is, after the presentation of the petition, you cannot pursue individuals for TUVs or preferences. You've got to look to void dispositions at that stage. This can have negative consequences, and especially we're going to see that in rewasu, in individual insolvency. Well, what are some of the defenses you might have to Section 127? You might be able to dispute the actual meaning of disposition. You might say that there was no disposition whatsoever of company property, or the timing of the disposition is falling outside of that relevant time. You might be able to get a validation order, either prospectively for a transaction which is going to happen in the future, or retrospectively for a transaction which has already happened. You might be able to argue change of position, which is an equitable defense, which can be raised against a claim for restitution. And if we're talking about individual insolvency in Section 284, you can look to the defense in subsection 4, which we're going to look at in detail. What doesn't work, and what I've seen quite often from people, is people arguing, we didn't know about the petition. Doesn't matter. Or, hey, we were a valid creditor of the company and we just got paid. Again, doesn't matter. It's a void disposition. It comes back unless you get a validation order or you can raise some other form of defense. There's no defense here of simply not knowing. Ignorance is not an excuse in void dispositions. It might actually go towards something else like a validation order, but by itself, it's not a defense. So how about disputing dispositions in their own right? Well, banks who are intermediaries in a disposition will not be held liable by themselves. We have the case of Coutts and Stock from 2000. In that case, it was found that the bank, in essence, what was happening was checks were passing between parties, and it was the bank who is in the middle as the intermediary was actually cashing the checks. They were pursued for the void dispositions. The court held that the bank was just, as I said, an intermediary, an agent, as it were, for the paying party. And in those circumstances, the bank itself had not accrued benefit. It was the individuals on either side of the transaction. So the bank won't be liable for these situations. Here's an interesting one. A binding and unconditional contract for the sale of an interest in land. As some of you or many of you might know, the actual equitable interest might pass earlier than the final completion of the sale. So under those circumstances where you have a binding and unconditional contract for sale for an interest in land and the equitable interest is already passed, and if that happened before the relevant time, even if the final completion occurs during the relevant time, the equitable interest will have already passed. So there is no disposition which can be attacked. And this kind of goes back to what we talked about in Akers and Samba in trustees. You look to see whether there's a beneficial interest in property which has gone back and forth between the parties. Again, there's a case there, Branson and Gothard Limited. I'm not going to go into it in depth, but if any of you want to go into it, then there it is. Where property is held on trust, again, I've already discussed this, just reading off my slides and realize I've gotten ahead of myself, not going to talk about it now, but where it's just the legal title passing and beneficial interest is invested in the company, it's not an issue. Well, what about disputing relevant time? So we already talked about contracts for the sale of property. There's an interesting element of checks. We don't see checks much these days, and I doubt we'll see many of them going forward because of the way that modern society is going. But the law as it regards to checks is quite interesting. So checks might be issued, they might be drawn prior to them actually being cashed. And what the original Australian authority, LOTICA, and what was then subsequently followed in this country by the Court of Appeal and the Bank of Ireland and Holocourt noted is that for the purpose of dispositions and checks, what you look at is you look at the actual issuing or drawing of the check. You don't look at the payment. When that issue when the check is issued, that's when the obligation is incurred. That's when the disposition occurs. It's not later when it's actually cashed at the bank. So look at the checks and the dates of the checks if that's what you're looking at. What about change of position? What is change of position? It's an equitable defense for a recipient in issues of restitution. And the briefest of summary is where an individual receives money without notice of the potential cause of action against the payee or of the money or the disponer of the property. And that person doesn't have notice and they receive it in good faith and they ultimately change their position in reliance upon the validity of that transaction, either by spending the money or using it for something which cannot be returned. In those circumstances where the court considers it unequitable to order return, then the recipient will not have to repay that money. Now, there's a lot of conditions there. They can't have known of a potential cause of action. They can't have the money sitting in their bank account or still have the property in question. And ultimately, it's a question of equity, weighing up the interests of the two different parties and whether the recipient's interests outweigh those of that party which is seeking return of the goods. Ultimately, this has been approved as a theoretical defense to Section 127. I cite the case of Rose and AIB Group. In Rose, it was raised and it was considered by the court as a potential defense that could be raised, but it was trashed on the actual facts. That was an instance where a company had paid money to a bank and the bank had a guarantee against the director of the company, and the guarantee covered various obligations that the company owed. In reliance upon payment of that sum from the company, the guarantee that the bank had against the director of the company was released. Ultimately, that company was wound up and the liquidator said this was a 127. The release of the guarantee was a disposition. What the court ultimately considered there was change of position was not relevant because when it released the guarantee, not when it received the money, but when it released the guarantee, the bank had knowledge of the winding up petition. So it didn't act essentially in good faith without knowledge of the potential cause of action. I've had some experience of change of position recently. Some of you who might follow the law reports know about the recent case of Bucknell and Wilson from May of last year, where change of position was for the first time applied to preference claims. We have appealed that judgment and we're in the appeal hearing is going to happen in May of this year. So watch this space to see whether change of position will be expanded to the area of preferences and transactions at none value or not. So change of position doubted, huge amount of text on this screen. I merely raise it because, again, this is near and dear to my heart because of my pending appeal in this matter. But there's the Skandiviska, I can never say that word properly, in Conway case from the Privy Council of 2 years ago, where the Privy Council had to consider change of position defense in regards to a claim coming out of the Cayman Islands. I'm not going to go into too much depth about the facts of that case, other than to say, in that situation, the Cayman Islands it was a preference claim actually, and there's no right of recovery for preference claims in the Cayman Islands. It's just an equitable right of restitution, same as 127. What the Privy Council held, however, was that while reviewing the authorities of change of position in this country as they relate to 127, the court said, we're not actually going to determine whether those authorities are right or wrong, but those authorities do not change our reasoning whatsoever. And what the court's reasoning ultimately was that the insolvency principle of pari passu is ultimately overwhelming in the face of change of position defenses. So the public interest right of bringing in the assets for the benefit of creditors is more important than the change of position for a single defendant. That was a policy consideration generally taken by the Privy Council. And by saying that they were not persuaded or did not take into account the authorities in this jurisdiction on 127, to some degree, they are kind of putting them in doubt without explicitly doing so. So the 127 jurisdiction under Rose in AIB, not overturned, but watch this space to see what's going to happen in the future. Someone might roll off the back of this Privy Council case and try to fight that in the future. Right, on to what everyone wants to hear about, Section 284. So exciting. The next two slides have the section set out in full detail. I'm not going to read in complete depth, but just briefly highlight it again. Subsection 1 quite closely replicates Section 127. Again, we're talking about dispositions of property made by a bankrupt in the period to which the section applies. Those are void except to the extent that it was made with the consent of the court. Again, that's the validation order element, or subsequently ratified by the court. Again, validation order. Subsection 3, so we actually have the relevant period contained within the section itself. It's the beginning of the date of the presentation of the petition or the making of a bankruptcy application if the bankrupt makes themselves bankrupt. Subsection 4 is what we're really concerned with in this discussion, which is a statutory defense, which we don't see in Section 127. So this marks Section 284 and personal insolvency as different from corporate insolvency. And what subsection 4 provides is that where the person who has received the funds did receive it in good faith for value and without notice that the petition had been presented or that the application had been issued for personal bankruptcy, then that person might not have to repay the money. There might be no remedy against them. That's important. So we're going to go into that in depth in the recent case of Rebus Sue in a second. Subsection 5 again talks about bankers and financial stuff. Not going to talk about that today. And subsection 6 deals with trustees. We'll come back to that in a second, but it's very similar to Akers and Samba. If the bankrupt was a trustee holding whatever item, property on trust for other beneficiaries, and as trustee disposes of those goods, that will not be caught by this section because the beneficial interest is held by someone else. So conditions of 284, to start with disposition, the same as 127. We look at what the disposition of, or what the definition of disposition might be. But what we can see in personal cases and what we sometimes see are divorce proceedings. So there's the case of Warwick and Yarwood's trustee in bankruptcy from 2010. In that case, divorce proceedings happened before the bankruptcy. Then I believe it was the husband was made bankrupt, and he was made bankrupt, or he put a petition was presented against him 3 days prior to the hearing of the ancillary order. At the hearing, various property dispositions were ordered between the husband and wife, and ultimately it was considered that this order, despite being an order of the court, was caught by 284 and had to be reversed. So even there, in divorce proceedings, orders of the court will be dispositions which can be avoided under 284. Again, we see this throughout a lot of case law. Insolvency law takes precedent over family law. Just the way it is from a policy perspective. The creditors outweigh ex-spouses or children. So it has to, again, be made in the relevant period. Again, we say that the explicit statement of relevant period is the presentation of the petition or the application to make oneself bankrupt. Again, you have the opportunity to validate if possible. Change of position, does it exist in 284? Well, it was kind of raised in the case of Re-Dye in front of the former chief registrar, Baster. Baster kind of left open the door for it to happen, but he trashed the facts of that case and stated that under the circumstances of that case, change of position simply could not exist. He kind of held that change of position probably shouldn't work its way into 284, but doesn't necessarily do so explicitly. And I don't know of any other cases where it has been applied in 284. So it might be out there, but really we don't see it. And especially in light of Conway, that might really have an uphill struggle to get run in 284 cases, especially because subsection 4 exists and there is a massive overlap between change of position and the defense of subsection 4. What about subsection 4? Here we go. Here's what everyone was asking about. It provides a specific defense to 284, which does not exist in 127. So don't get confused. Don't try to apply this to corporate insolvency. They are entirely different statutory defenses and regimes. It is a defense of an innocent third party receiving the disposition without notice of the bankruptcy petitions in good faith and for value. So there's 3 distinct issues we have to look at. Issues of good faith, issues of without notice, and issues of valid. Notice is obvious in nature. If the recipient knew of the bankruptcy petition or application, then they cannot make use of 284 subsection 4. It's just out the window. So if, say, a spouse or a friend of the bankrupt knew that the individual was facing these proceedings and the bankrupt transferred funds to them in any event, either to pay a debt or for some other reason, well, that's it. Too bad. Doesn't matter how in good faith you were or what value you provided for those goods. If you knew of the petition, it's game over. Good faith. Well, good faith is a little more interesting. One might think initially that good faith is actually simply the absence of dishonesty, but that's not quite right. We deal with the issue of Sands and Wright from 2010. It's basic facts. The bankrupt ended up paying one of his creditors, a creditor who'd been pressing for a significant amount of time, for about 9 months, for payment of his debts. And the bankrupt paid that debt after presentation of the petition. The creditor didn't actually know about the petition, and there was nothing dishonest per se that the creditor actually did in this case. But the creditor did know that the bankrupt was struggling to make payment to itself and to other creditors. So it had a strong, or would have had a strong suspicion in the opinion of the court, that payments would have been falling within a period or potential bankruptcy period. So in circumstances, it's not merely the case of absence of dishonesty. A creditor cannot bury one's head in the sand and simply not listen or take a view of what's going on around. If there's a lot of suspicion over the potential bankrupt making payment to that individual, and there's some suspicion that maybe the person's getting paid when something bad's about to happen or others are going unpaid, then the court might say they were not acting in good faith. So again, you need to look at the recipient, what they knew under the circumstances, even if they didn't know the petition. But what about the issue of value? And this is what Riwasu and Judge Prentice really got to grips with. Value had not been properly argued before. So basic facts of the matter: the bankrupt was a dentist. He was a judge bankrupt in October 2013. The petition had been presented by HMRC for unpaid taxes in March of 2013. So you got about, 7 months there between the 2 periods, which is the relevant period. There were 2 respondents of note. The first was a respondent who had purchased dental equipment for onward lease to a partnership of dentists, which was held by the bankrupt's parents. The bankrupt was the guarantor of that liability incurred by the partnership. The partnership ultimately defaulted on the monthly payments for the goods, and in August 2013, so in the middle of the relevant period, the bankrupt paid the initial rent installments by check. But he himself was not necessarily receiving value for those items, at least not the full value, as he was just the guarantor for a partnership. In the second respondent issue, that respondent was a landowner who had let premises to a company. The shareholders of that company, which was there simply to rent the land, were the bankrupt and his parents again. In mid-2013, the bankrupt made 3 payments in respect to the rent, so not the company making the payments, not the company which had the lease, but the bankrupt made the payments. So he's not necessarily seeing value coming back because it's not his lease that he's paying the rent on. Although obviously there might be some indirect value, because if he's a shareholder in that company, or if he's operating as a dentist out of property which is leased by that company, but it might not be full value. So all parties agreed that the payments were dispositions, and the trustee accepted that in receiving the payments, the 2 respondents had acted in good faith without notice of the petition. So there was no fight on those issues whatsoever. Trustee probably thought they had it good here on this situation. The central issue then was the issue of value. What did that mean? Well, the trustee argued that value required an interpretation of full market value for the property disposed, for the rent or for the guarantee payments for the goods which have been purchased, and sought to draw analogies directly with Section 127. Conversely, the respondents argued that subsection 4 doesn't actually say full value. It simply uses the word value, and that the corresponding analogy between 127 and 284 was simply incorrect because of the different natures of those sections. Well, the judge ultimately made a decision on two broad grounds, potentially three. First, that 284.4 only uses the word value without making reference to full value. So he just read the section as it says. He noted one would have to read in substantially greater wording to bring it into the ambit of section 339, which is undervalues. And we'll look at that on the next slide, just to compare the two sections. He also said there were two competing principles. There's obviously the principle of pari passu, so all of the creditors of the bankrupt going as one. And on the other hand, the equitable defense for innocent third parties unaware of the insolvency, which is very akin to the age-old idea of equity's darling, purchase for value without notice. In those circumstances, he weighed up the competing principles. He thought, under the circumstances where value is not explicitly said as full value, that the defense of the third party's innocence was ultimately paramount, because that's what subsection 4 is trying to raise. It's trying to give a defense to an innocent third party. And that was paramount over the pari passu principle of insolvency. Now, in regards to the actual issue of value, he did note, and this was raised as an issue, something which I raised earlier in this talk, that void dispositions and transactions at an undervalue don't overlap. The relevant period for TUVs ends with the presentation of the petition. So he did note that section 339 gave a specific definition of what value in those circumstances or what undervalue would be. And that's quite a substantial definition. I've set it out here under subsection 3 of section 339. But especially it's either a gratuitous payment under A, or C, it's payment for consideration, the value of which in money or money's worth is significantly less than the value in money or money's worth of the consideration provided by the individual. So there, in the same act as section 284, there's a definition which goes in depth as to what value is and how it is defined. 284 doesn't do that. It just says value. It doesn't say undervalue. It doesn't go into it. So under those circumstances, the judge said, well, we simply have to take it as it is. Value simply means value. Now, what is WASU doing? Well, it's continuing the trend of protecting third parties and watering down the primacy of the rights of creditors in the pari passu principle. I made reference to my own case of Bucknell and Wilson earlier, and we'll see what happens on appeal. But this is generally a trend, I think, which we're starting to see, which is courts protecting third parties, innocent third parties in their mind, more and more at the expense of the creditors. This does create a loophole, ultimately, in the Act. So as I said, TUVs don't carry in to the period after presentation of the petition. And now you can have an undervalue transaction to a recipient if that person received it in good faith and received it without notice of the petition. Already preferences are already excluded by the relevant times as well. So it might be that as a result of the way that the Act is drafted, you're going to see things which might otherwise be reviewable transactions outside of the relevant period now being allowed under 284. Now, obviously, this is not some loophole which people can easily exploit because of the issues of good faith. So anyone who's trying to go around this in some fashion, family members or whoever who know of the petition or even know of the financial difficulties of the bankrupt aren't going to necessarily be able to make use of 284. We'll probably see it in the context of commercial transactions with a creditor who's at an arm's length distance and simply doesn't know that much about what's going on with the individuals. Finally, we'll talk about trust property quickly. I already talked about this with Akers and Samba and highlighted subsection 6 earlier, where the bankrupt is trustee and he transfers something or she transfers something to which they're not beneficially entitled. That's not going to be void. That transaction or disposition will stand. And that makes sense as the bankrupt ultimately is not suffering a loss of any beneficial interest or equitable interest. There is no loss to the estate of the bankrupt. It's someone else who actually has the value for those goods. Validation orders. I know Matt read my slides and really liked this line. Too much material to consider for today, and I am tired. I am tired. We don't have time for validation orders. It's already past noon. We've been going for an hour, so we're going to move on to questions and answers in a second. Validation orders are a huge subject. They're questioned in their own right. Hopefully myself, Matt, or someone else will talk about them soon. We can always answer your specific questions on them. But ultimately, the court can prospectively or retrospectively validate a transaction in insolvency. And that's me done. There should be my name there. I forgot to do it. Hooray.
Anonymous has asked me, what happens to the running of time where the insolvent company is in administration in which a distribution is to be made? Does time stop as in liquidation, or does it continue to run? Now, I sort of glossed over a bit the issues with administration because there's quite a few different rules depending on what happens during the administration and after it. There is a very worthwhile textbook called Insolvency Litigation, A Practical Guide, written by Radcliffe Chambers. Paragraph 921 summarizes the position very nicely. Now, in my talk, I focused on the simplest situation, which is where there's no distribution, the administration ends, but the company resumes trading or is dissolved. In that situation, because administration does not suspend limitation, the claim is likely to be barred. However, if a distribution is made during the administration, then Rule 14.1 and 14.2 of the insolvency rules will apply, and the creditor will be able to claim a distribution if their debt was owed on the relevant date, just like in liquidation. So those are two of the options, but there are others, so that's hopefully addressed that question. The second question for me is from Anonymous, and Anonymous has asked, what would you say the limitation period is in a trustee's application for a declaration of beneficial interest / possession and sale where section 283 does not apply? Now, in my submission, if you're simply sort of looking at a claim to increase the assets that the bankrupt could have made themselves, then what we're really looking at is a claim brought on their behalf. So paragraph 2 of Schedule 3, and we're within the scope of my first rule, which is that liquidation or bankruptcy doesn't affect the underlying limitation period for a claim brought on behalf of the insolvent party. Now, the general rule is that a claim to recover trust property is subject to a 6-year limitation period. That's section 21.2 of the Limitation Act. So my suggestion would be that 6 years is likely to be the starting point there if we're essentially outside the scope of the Insolvency Act and simply bringing a claim on the bankrupt's behalf. Rachel has then written quite a long question, and she says, in the case of Haysport Properties, it was held that time for limitation had not started to run until an independent board had been put in place. What are your thoughts as to whether this could apply in circumstances where a liquidator is appointed in place of a prior IP whose insolvency license was revoked due to conduct? Now, that's obviously a very specific case and a very specific question, but here are my thoughts. So Haysport concerned essentially a claim for breach of duty against a conflicted director of two companies. And the relevant finding for our purposes is that time was suspended under section 32 of the Limitation Act because he deliberately concealed his wrongdoing. Now, as I emphasize, this only suspends the limitation period. Limitation starts when the fact that has been concealed could have been discovered. And the court said this could have been discovered when he was removed as a director and someone else was appointed in his place. And that's not quite analogous to a situation where a liquidator is making a claim on behalf of the company or a liquidator is bringing an insolvency application. That said, there's generally a debate about whether limitation starts to run on the winding up order or the appointment of the liquidator themselves. Now, in my view, the better argument is it's the appointment of the liquidator, because that's the person who's then capable of bringing the claim. And that was, for example, what counsel conceded in re-Ide, although the Court of Appeal didn't express an opinion on it. But the cases are not consistent. And your scenario suggests to me that at the time the first IP was appointed, they had a valid certificate and they were properly appointed. So in my view, in those circumstances, there's a risk that there would be no suspension because you had a valid IP in force at the time, and there's some debate anyway about whether limitation even starts after the order is made.
In terms of the issue of transactions entered into, this is Max Morrison's question, entered into pre-presentation of the petition, which have been challenged as void dispositions. Would the transaction have to be formally completed prior to presentation of the petition to fall outside the scope of section 127? So the only matter to be finalized after presentation of the petition is the physical transfer of the asset. Well, I talked about that briefly, Max, in my discussions. I probably went too fast over it, but especially in discussions of sales for property of land or checks, where there has been a contract which has an unconditional contract for the sale of an interest in land, say, which is binding and you can't get out of it, the equitable interest will have already transferred. So the mere handing over of, say, keys later on would not reflect an actual disposition. So look to see when the actual equitable interest in some property transfers. Same with checks. If the check is drawn prior to the presentation of the petition, it's merely cashed afterwards, the disposition is when the check is drawn. So again, just look to see when the equitable interest is passing as opposed to the legal title to something. Sanjeev, you had a question about section 84, creditors' interests. Specifically, you noted that, I think you were summarizing what I was saying, the creditors' interests are in priority to spouses or children. What if a property transaction is reversed and leaves a spouse and children homeless and an ancillary relief hearing has yet to be heard? Will the courts deprive the spouse of the home and periodical payments for the children? Potentially. So generally speaking, the rule in insolvency cases is that insolvency law in the interest of creditors does have primacy over the interests of the individuals. Now, the courts in the past have taken that view. The courts have also, while saying that the insolvency rules take precedent over personal matters such as family members and such, they might give a little more leeway. Judges ultimately are human beings, and so they might give more time or conditions on the return of property. We've all seen it in applications under 336, that even where explicitly in the statute it is said that the interests of spouses and children are irrelevant, unless there are exceptional circumstances, even then the court might extend the period with which possession must be given to 6 months, say. But ultimately, there is case law to the effect that homelessness or a change in circumstances for the negative for individuals is part and parcel of the modern law of insolvency, and unfortunate as it might be, is the statutory scheme. Now, it might be, if change of position can be proven, that maybe the courts will protect the interests of that spouse. So if the spouse received those goods in good faith, received without notice of the petition, and someone did something with those goods so that they disposed of those goods and it would be inequitable to return them, that's what we're dealing with in my appeal in May, then the court might step in. And obviously subsection 4 gives them a defense as well. Again, if it's for value, for some value, and it's done without notice. But ultimately, the family courts do not overrule the insolvency courts, as unfortunate and painful as that might be. Those are the two I've looked at. I think there's a final question here from Paula. Is that for you, Matt? I haven't actually read it yet.
Yes, Paul has asked, what would your general advice be for an office holder who's looking to ignore the 6-year limitation period for a monetary misfeasance claim and rely on the Burnden case instead? Well, the short answer is Burnden was about the trustee, i.e. director, holding trust property, i.e. company property, in which case there's no applicable limitation period. If you can get your case within that scenario, then yes, obviously that's one way of trying to avoid the limitation period. That was one of my 5 practical tips, looking at the exceptions in the Act.
I'm going to jump in here, Matt. Sanjeev has then done a follow-on question. He's just noted that spouses in most cases will know of the petition. This is going back to my previous question with Sanjeev. Well, if they know of the petition, Sanjeev, then they're in trouble. The courts are going to say, if you know of the petition, you should not have been accepting the disposition of property. In those circumstances, the statute is quite clear. It has to go back. That's just the way the Parliament has drafted things, and we can't go behind Parliament in these things.
Thank you very much, everyone, for joining us and for listening to all those answers to all those questions. It's been great to have lots of engagement. Our junior program continues next with a private client seminar, but look out for further insolvency and other commercial seminars later in the year as well. Thank you very much for joining us, and goodbye from me.
And goodbye from me.